We have an awesome real-world learning experience for you today. Court of Appeals, we want to thank everybody being here today, providing this awesome opportunity for our students. This is about as real-world as it gets, guys, so this is amazing. One of the many great things about my young ladies being here, because of great work that other people have done, and so I'm going to present to you Mrs. Melanie Hartman, who put this whole event together. She's going to explain a little more about it. For those who aren't our friends from Turpin and aren't aware, if you do need to use the restroom, they're located just outside of Titus Auditorium. Go out and go right if you need that, or any of our guests for that matter. That's where those restrooms are located. Okay, with no further ado, Mrs. Hartman.
All right, guys. Well, I'm really glad you're here, and we want to welcome the Ohio First District Court of Appeals to our auditorium today. This is part of their courtroom in the community program. The First District provides local communities with educational initiatives like this to allow you the opportunity to view the Ohio judicial system in action. The First District Court of Appeals is one of 12 appellate districts, and it deals with cases all throughout Hamilton County. Its job is to review decisions made by lower courts and see if they were right. A panel of 3 judges, including presiding Judge Ginger Bach, Judge Robert Winkler, and Judge Jennifer Kinsley, will hear 2 cases today. One about a crime and one about something civil, meaning non-criminal. Each side in these cases gets 15 minutes to explain their point of view. Before making decisions, the judges read documents, they check records from the lower court, and then they do some research. After hearing arguments, they discuss the cases, and one judge is randomly chosen to write a detailed explanation of their decision. This is called an opinion. If a judge disagrees, they can write a different opinion, called a dissenting opinion. Even though this is not a typical courtroom, it is important to follow the rules as if it is. Please turn off electronic devices and do not talk during the proceedings. After the cases are discussed, the judges will come back to answer any questions that you have. I encourage you to ask questions. The whole process is public, and it can be watched on the court's YouTube page. We're really glad that you're here today. Good morning, everybody, and welcome to the First District Court of Appeals at Anderson High School. We're very excited that we have so many students here watching, and I hope that this is a great experience for you. We have 2 cases that we are arguing this morning. And when I state the name of the case, would the counsel please stand up, state your name, and your readiness to proceed. Our first case on the docket is State v. Williams.
My name is Phil Cummings. I'm with the Hamilton County Prosecutor's Office, and the state is the appellant in this case.
Maura Peters, I'm from the Hamilton County Public Defender's Office on behalf of Sullivan.
Thank you. And then our second case is Schaefer versus Levy.
Morning, Your Honor. Matthew F. Peters on behalf of Lee Schaefer.
Morning, Your Honor. Justin Whitaker on behalf of the appellee, Sandy Levy.
Thank you so much. I will keep the time, since we don't have the light system, I will just wait and have about a minute to go. You can come on up, Mr. Prince. Is there any time?
Yes, I would. 5 minutes.
Okay.
Also, as a bit of housekeeping, I'd like to direct the court's attention to page 19 of the state's brief. About the 4th line down, a word that is reason access should be assessed. I just wanted to make that clear. Your Honors, I think in this appeal, it's a very straightforward point the state's trying to make. The state's contention here is that the trial court below erred as a matter of law in finding that this search was unconstitutional. In fact, the state maintains, it's very clear, this wasn't a search at all. This was a protective sweep, which the law provides for. And I think that when the court reviews the totality of the circumstances, which the court is required to do, it will become clear that this case actually represents a textbook example of an illustration of the circumstance that warrants a protective sweep. I know this court has read the record, but I think it's important to go through the totality of circumstances that supports the state's contention here. This is not a normal traffic stop. This was not a normal interaction between police and citizenry. As the court is aware.
Counsel, was this a traffic stop at all? I mean, wasn't Mr. Williams' car already stopped when the police encountered it?
Good point. It was already stopped and parked at the curb. So technically, this was not a Terry stop. It was a Terry detention because Mr. Williams was already stopped at the curb. So this was not a stop in that sense. But Mr. Williams was detained. And
Does that matter? Does that make any difference in terms of the officer's reasonable belief of danger?
That particular fact that he was already parked, I don't believe weighs for or against the totality of this particular circumstance. I think that keep in mind the officers were directed to find Mr. Williams and detain him where he parked for very specific reasons. He was observed by an undercover officer committing multiple traffic violations while avoiding police. Basically, Mr. Williams saw the interaction of uniformed officers up ahead and deliberately maneuvered his car to get the heck out of there. He did an illegal U-turn. He ran a stop sign. He turned in front of another car. He traveled at an excessive rate of speed. And all of this, as the officers testified, is it's indicative of somebody that they often see who is afraid of police. They want to avoid the encounter for whatever reason, but the officers see this quite often among people that don't want to interact with police. So that sets the table here for this interaction. The undercover officer observed Mr. Williams evade police as soon as he saw them. He wanted to get the heck out of that area. Keep in mind that the undercover officer and the uniformed officer are in this area in the first place because it's known to be a very high crime area with a lot of guns, a lot of violence, and a lot of shootings. And these officers themselves are part of a specific unit with the Cincinnati police to find and detect and try to get these guns off the streets. That's what all the police presence is there for. So with that backdrop, we have the undercover officer view Mr. Williams evading what he sees ahead as uniformed officers making a stop of a different individual. So right off the bat, you've got multiple traffic infractions, which gives the officers probable cause to cite Mr. Williams. They don't even need suspicion at this point because they have officer witnesses who have actually.
What's the basis for opening the door? I mean, that's really what this case is about, as to whether the officer approaching on the passenger side of the car could open the door. And what do we know in terms of whether that officer had a reasonable belief that she was in danger at the time she opened the door?
Well, we know a lot of things. We know that what she knew at the time was that they were in a high crime area. They were trying to get guns off the streets. An undercover officer told them to detain this person because he seemed to be acting in a way to avoid the police. In fact, he committed many crimes to get away from the police. And as her fellow officer exited her cruiser, they noticed that Mr. Williams, in a very agitated state, got out of his car initially and started to confront them. The officers testified this is abnormal. This is not the usual interaction when you approach a car. Keep in mind, I don't even think that he was initially aware that they were coming around for him. So for him to jump out of his car initially, I think gave some pause. That made them concerned. She knew that, and she knew that he was already out of the car before her partner was even able to get up to the window to talk to him. So his behavior is already starting to develop a pattern. He's already been known to be evading police. Now he's physically jumping out of his car and confronting them. So two things right off the bat. He's a red.
When he was ordered back into the car by the first officer, the one approaching on the driver's side, he complied with that instruction, didn't he?
I think he did get back. However, there was concern because both officers testified that he had excessive tint on the automobile windows.
But didn't he, I watched the video several times, it appeared that when the officer told him to lower the windows, he began to comply.
There was testimony that.
No, I'm actually watching the video,
On the video,
that's
that's what Judge Triggs mentioned as well. But that is something that goes to the totality of circumstances. I don't think that the officer Carter on the side was certainly aware of that. She did not know that he was attempting compliance.
But you could see on both videos that the passenger side window was beginning to lower as she was opening the door.
But, true, but she did not know at this point what had been said, if anything, between her partner and Mr. Williams. The circumstances of this stop rendered the officers essentially blind and deaf. They couldn't see into the car because of the tint. They had a hard time hearing.
Officers would always be able to go into a car and start opening doors and intruding into the cabin of the car if they can't see inside. There's many circumstances, so tinted windows are one, but I could think of maybe weather situations, like pouring down rain or something or glare might impede your ability to see into a car. So is it a bright line rule that when they can't see, that they would be able to go in?
No, that's the hallmark of these types of cases. There's no bright line rule. It's always look at all the circumstances. That's why we have the totality of circumstances. Yeah.
Mr. Cummings, let me ask you a question about I know it's heavily tinted windows. The FedEx began to roll down the windows. The trial judge said that it was premature to open the door. So my question is, had he complied and rolled down the windows, the gun, at least as far as we could tell, would have been clean. He wouldn't have that back rear window been open. The gun was the passenger seat, and as soon as the judge opened, or as soon as the officer opened the door, she saw the gun, or she saw the front of the gun. So I guess there's a much ado about nothing that the officer opened the door, maybe prematurely, when had he complied, he should have seen the gun.
That's a good point. I wish I'd argued that. It's almost like an inevitable discovery. But I see my time is up, so.
You have another 30 seconds. You want to
I just think that it's in this particular circumstance, it's just not the tinted windows. You have to remember the music was blaring, and he made no effort to turn the music down. So the officers couldn't hear each other, they couldn't hear him, they couldn't see into the.
So the music, it seemed to me like when they first got there, the music wasn't on. It seemed like he might have hit a button or something, and Mariah Carey started playing very loud. But then, that wasn't at the very beginning of the stop, though. Am I wrong about that?
No, no, but I think that he jumped out initially and started to confront them, and then, when that happened, they couldn't hear. And I think it just lends more to the totality, but I'll follow up with it.
Okay. Whenever you're ready.
Good morning, Your Honors. May it please the court again. I'm Laura Peters. I represent Saul Williams. I'm going to start off just on, I think where we kind of left, which is the examination of the videos. Now, I do know, and in doing so, I think we're going to correct some misconceptions about what the facts actually are, and even probably some in my brief, because unfortunately I didn't have a chance to view the videos before. I found my brief, the records custodian couldn't locate them until after the day after I found my brief. So, if we start with the video, and I think this also goes to, Judge Winkler's, question about what Officer Carver know. So we know from her viewpoint, from her video, what she knew. So, and with additional testimony about, yes, they were told about the traffic violations. Yes, Officer Jennings testified, he told them that, my client had done a U-turn, what in his estimation and his experience was because he was trying to avoid the traffic stop unrelated to him. And there's absolutely no connection to my client to this task force that was investigating an area of the Dutch Colony apartment complex that was over a mile away from where my client lived, and that's where he ultimately was his car.
So counsel, does that impact the range of calculus that a person might be avoiding contact with the police?
It could if we knew for sure that that's what he was doing. We don't know if the road was blocked because of the traffic stop. So maybe he was doing a U-turn because he didn't think he could safely get around it. Or if he just was like, the traffic is backed up because of this traffic stop and I want to get home and I have an alternative route. So no one knows exactly why, but I will admit that yes, the U-turn is a traffic violation. And therefore the officer's approach to the vehicle was lawful. And
Is it a reasonable assumption for a police officer to assume that a person is dangerous because they don't want to encounter the police?
no, I think in this world and day and age, my client is a black man. He probably does not want to have much interaction with the police, given what's happens in society. So no, I would not necessarily assume that anybody who says, well, I see, you just might even want to avoid trouble. So, no, it's not a fair assumption to make when someone tries to avoid the police that they're necessarily armed and dangerous. And that goes back to actually what Officer Carver did. She said she made an assumption. This is like a hunch. Her assumption was based on that she thought, though she didn't know if Officer Owens Jordan had ordered my client to roll down the windows. She assumed he was being non-compliant. So when she gets out of the vehicle, which is about 30 seconds into the video, she gets out, she puts a stop stick behind his back wheels, or in front of his back wheels, and she gets on her radio to call in the report, and as soon as she gets off the radio, she opens that door.
Let me ask you a question, ma'am. Do you see any constitutional question about the police either requesting that your client roll down his windows? You saw the video, you cannot see that.
I'm having trouble hearing you.
Is there anything constitutionally deficient that you are aware of in requesting that somebody be rolled down their windows if they're heavily tinted?
No, there's nothing. No, I can't say that there's any constitutional violation going on for rolling down the windows.
If he's done that, then I guess it's the same question I asked you Cummings, then wouldn't that firearm have been readily apparent?
I don't know, and we don't know because Officer Carver didn't allow that to happen.
The judge said she did it too soon. The officer opened the window.
Right, and we also don't know how far down that window was gonna go. We don't yet, so that back window, so maybe it doesn't go down far enough because the gun was in the pocket seat. And not much was showing, actually. With the full door open, she had an unfettered view. We don't know how far that window would have gone down because notoriously back windows don't always go down the full length like the front ones do.
Has the state waived the argument that it would have been discovered anyway?
Yes, they didn't argue it below, they didn't argue it in their brief. So that argument is waived, as well as their argument on the good faith exception.
What can we do with the fact that Mr. Williams was coming out of the car, he was yelling commands at the officers, and then he was ordered back into the car to comply? How does that affect the reasonable belief of danger?
Well, Judge Tinsley, I think if you actually look at Jordan's video, You see her get out of the vehicle, and you actually then see his car door open. He never exits the vehicle. So her order is stay in the car, not get back in the car, it's stay in the car, and yes, he complies. Because he's being compliant, at that point in time, yeah, he's being compliant, he might be upset because he's being pulled over, he doesn't understand, you know, these uniform, as far as he knows, these uniform officers have no reason to be engaging him.
Is it reasonable to assume that because someone is upset with the actions of a police officer, that they present a danger to the police?
No, it's not reasonable to assume that in every case.
Why is that?
Because people have different reactions to the police, and again, in this day and age with him being a black man, when you're having this engagement and you're not expecting it, him being upset doesn't necessarily mean he is armed and dangerous. He didn't threaten the officers. Owen Storm testifies that she had no concerns as she approached him. She had no concerns. She could see his hands are visible in the video. He didn't make any furtive movements. He didn't exit the vehicle. As Judge Bakke kind of indicated, the loud music didn't turn on until he kind of fiddled with something. My guess is that he had it when he turned on the car to roll the windows down. And then Mariah was blasting. So, but the officer that we have to focus in on is actually Officer Carver, and what did she know? She didn't know if her partner had issued an order to roll down the windows. So her seeing the windows still up is just an assumption, it's not a fact, it's not reasonable for her to assume that my client is armed and dangerous because he may or may not have been compliant with an order her partner may or may not have given.
So, counsel, something I noticed at the suppression hearing is that Officer Carver testified that she became afraid when the first officer moved forward to the front of the car. And that sounds to me like her fear was piqued based on something that her fellow officer did, and not based on something that Mr. Williams did. How do you weigh Mr. Williams' actions versus something that her fellow officer did in looking at the reasonableness of her fear?
Well, it has to be under Michigan versus Long, the United States Supreme Court says there has to be reasonable articulable suspicion about the driver in this case that he is armed and dangerous. So I don't think it's fair to say because her partner, she was saying, I don't know, she actually said she feared, but I don't recall, but she said concerned and she knew that she thought her partner's safety was on her shoulders because her partner was violating their normal procedure. By going farther when the windows, so she said the normal procedure is if there's dark windows and they stay back. Well, her partner didn't comply with that normal procedure and went forward. And that's because her partner could see Mr. Williams, and was engaging him. Yes, he was loud. I'm not going to dispute that he wasn't loud, but he was loud, but he didn't present a threat. He didn't give them any reason to believe he was armed and dangerous. And that's what's required to do a protective sweep. So I disagree because that this was a search. It might not be a search for evidence. It was a search for people and for guns. A protective sweep is still a search under the Fourth Amendment and Michigan versus Long, since you have to have reasonable articulable suspicion about that person being armed and dangerous in order to justify a protective sweep.
And the state has argued that this was a high crime area with known presence of guns. Does that affect the reasonable belief?
A high crime area in and by itself can never justify a protective sweep. And this court has said that in State versus Ward, which is cited in the state's brief. And then also in State versus Henson, that was cited in, I believe, Henson, in my brief, that just being in a high crime area, you have average citizens in a high crime area, just because they're in a high crime area, or they have tinted windows, should not be an automatic pass to search their vehicle. When they have present there's no fact, something that is specifically can point to. There was no specific doing other than being loud. And there's been no evidence or understanding of how he was being loud as a correlation with him being armed and dangerous. So the high crime area with tinted windows, that's a general specific concern that yes can add to the totality, but you still have to have that reasonable articulable suspicion that's specific to the defendant. And in this case, there was none. So therefore, the trial court's decision is correct in this case. And if there's no further questions, we just ask that you affirm.
Thank you.
I think, just to take a step back, it's important to realize under the Fourth Amendment analysis that the touchstone of due process is reasonableness. Is it reasonable to do what the officer did here? At the end of the day, that's really the question this court has to answer. And it's going to be sending a message to law enforcement if it tells officers that they would be unreasonable in this circumstance, acting as this officer did. And I don't think that is something that can be done. I don't think that the officer here can be said to have acted unreasonably, given what we know. And all of these factors.
Can you address my question about Officer Carver's testimony in this suppression hearing? That she began to feel that the situation was more unsafe when her partner advanced to the front of the car. And my question is whether we can consider something that a fellow officer did in looking at the situation, or if we are strictly to focus on what Mr. Williams did.
No, I think this court absolutely has to take that into consideration. Her partner did advance on the car, and that is part of the totality of the circumstances here, and that gave her alarm, because I think she said that her partner kind of crossed the Rubicon there. Usually they wait under the protocol until they can see inside cars and the windows are down before they approach them. For whatever reason, the way this quickly evolved and unfolded, she realized that her officer was now, approaching a car. She couldn't hear, they couldn't hear each other communicate. They couldn't see inside the car. They knew that the defendant had already committed many violations of law trying to get away from them. He was already yelling and agitated as they approached. And she had to make a split-second decision to act to protect the safety of her fellow officer. There has never been any hint in this case that this was a pretextual action on the part of the officer. I think it was just a given as this unfolded that this Officer Carver acted in good faith. She truly did this protective sweep for officer safety. And I think that that's a very important point to keep in mind. This wasn't a search. And this is exactly why we even know the phrase protective sweep. This is why such a concept exists in law. When you have this type of a situation evolving quickly, she had to make a split-second decision, and it might have saved her life or her officer's life or Mr. Williams' life. And I think it's very dangerous when a trial court says this action was unreasonable. I mean, all this is true. All these factors were there. It was premature. And that gives me pause, because that implies that, if we'd given it, another 5 or 10 seconds, maybe it would have been constitutional. That's not the way things unfold on the street.
Mr. Price, this was some statement from the trial court that it was premature. Was that a factual finding or was that a legal conclusion?
I think that was his conclusion, given the testimony as it unfolded. It was his evaluation of the evidence that was premature, because that's kind of a subjective observation of the court's order, based on hindsight. But, these officers don't have the benefit of hindsight. They have to act in the moment. And I think it's important in a case like this, bottom line, to tell officers that, when things are unfolding like they are here, just as they happen, it's not unreasonable for you to act the way you did to protect your fellow officers. I think that's important to send a message to law enforcement. And I think there's no indication here that this was a pretext at all. And I think basically this was reasonable. And I think that the officer acted reasonably. Maybe in hindsight, if she had waited, things would have been different. But what ifs and second guessing is often, printed on epitaphs. And I think that we're all kind of heightened now in this day and age to err on the side of safety. I wouldn't send a message to the officers to make them second guess that kind of, I guess. Unless you have any further questions, we'll just say this.
Thank you very much. Your piece is now submitted, and we will issue a final decision.
Right.
And if we could have, switch places with the other attorneys, that would be great. Come on, would you like to reserve time? Would you like to reserve any time?
Good morning, Your Honors, and may it please the court. The matter here, the law concerning the matter before the court is pretty clear, at least in this district. A discovery request seeking attorney communications necessarily implicates the umbrella of attorney-client privilege. And it's an abuse of discretion for the trial court to forego an in-camera review or evidentiary hearing in demanding that evidence be produced. The facts underlying this case are really not subject to much, I think, reasonable dispute. This case has been going on for quite some time. I think that's clear from the record. It's been going on for about 5 years. And it originally started as a trespass action brought by Ms. Schaefer to recover damages for that she alleged was caused by Ms. Levy and a third party, which resulted in damage to 2 white pine trees. It's since evolved a little bit into a case featuring counterclaims for abuse of process and spoliation, as Ms. Levy alleges that Ms. Schaefer destroyed the trees, those 2 pine trees, before inspection. So on June 7, 2023, Ms. Levy filed and served a subpoena demanding the production of documents, communications, and ESI exchanged between Ms. Schaefer and her then counsel concerning the removal of these pine trees.
So, counsel, one of the claims that you raise is that the subpoena cannot be served on a party, and so is Ms. Schaefer a party to this litigation at the time the subpoena was served?
Absolutely, Your Honor. She absolutely was. And that is an argument that we raised and we stand by. Rule 45 couldn't be clearer that that's not how we get discovery from party litigants. We have interrogatories, we have document requests, we have requests for admission. And interestingly, at the same time that this subpoena was served on Ms. Schaefer, she was also served with interrogatories by Ms. Levy as well.
And because this case has somewhat of a complicated procedural history with different parties coming in and out to different claims and counterclaims and cross-claims, can you explain for us what part of the case Ms. Schaefer was still a party to at the time that the subpoena was served?
Ms. Schaefer was still she was a counter-defendant at the time. So the remaining claims were Ms. Levy's claims for abuse of process, I believe, and damages related thereto. I think the spoliation claim was dismissed. I think that was before my tenure in this case, but as far as I can recall right now, that Ms. Schaefer was a counter-defendant.
Let me ask you this, sir. Did anybody suggest to the trial judge that she ought to get an in-camera inspection the record of the attorney-client records prior to ordering the disclosure? Did anyone suggest that to her?
No, Your Honor, no suggestion was made. I don't think, though, that lack of a suggestion is fatal in this case. This would not be the first time that issue has come up. And in the case Haley versus Dieter and Sons out of the 2nd District, the trial court was faced, or the appellate court was faced with the same issue that you were faced with. And in interpreting Haley versus Masterizo, the court said that effectively, well, not effectively, just blatantly said that failure to seek an in-camera review or a hearing is not fatal to an assertion of attorney-client privilege on appeal. I think that that's a real a signal from how other courts have viewed this court's prior opinion that, attorney-client privilege is not abstract. It's not something that can simply be avoided and a party can avoid the scrutiny of it by a simple omission or failure to do that.
Was there a privilege law filed at any point? I can think of, I'm just hypothesizing because we don't know what universe of documents would actually be responsive, but I can think of some that maybe would not be attorney-client privileged if they existed, maybe something like a Christmas card picture taken in front of these trees or something like that. Let's say that exists, and if it did, it wouldn't trigger the privilege. So was some law generated to alert the trial courts of what we're talking about here?
There was no law generated because fundamentally this was an improper subpoena. Ms. Schaefer was really under no obligation to respond to it. Again, Rule 45 is clear that you cannot request those from, you cannot use a subpoena to acquire documents from a party litigant. I think it would be to hold otherwise would be effectively declaring open season on pro se litigants, who, even though we may presume that they know the rules, they don't know all of the rules in this case. But no, a privilege law has not been produced or even created by my office.
Could one be generated?
One could upon issuance of a proper discovery request. Absolutely, if they.
There's anything that remains of this case, a determination by the trial court whether your client engaged in privileged conduct. Is that all that's left at this point?
Correct, Your Honor. The trial court did issue a ruling on issue default, and that is currently now coming up for appeal, but
In order to change, that's not part of this case. They're not part of what we have.
correct. Correct. The only matter here is the issue of whether the trial court is required, it's a mandatory duty to hold that in camera or be able to hearing. And if the issuance of subpoena to acquire documents from a party litigant is procedurally improper. Your Honors, I think if there's no further questions at this time, I preserve the remainder of my time for rebuttal. I believe I've addressed the issues.
Thank you.
Thank you.
Morning, Your Honors. May it please the court, Justin Whitaker for the appellee, Sandy Levy. There are two independent reasons why the appellant's appeal failed as a matter of law today. First, their appeal was from a routine discovery order from Judge Branch ruling.
I'm going to stop you and ask a question now. Because the discovery request was specifically asking for attorney-client communications, how does that not make this a final appealable order? Because it does implicate privilege, even if, the claim is, it wasn't privileged because she talked about it, she made privilege, but isn't that something that the court needs to examine?
Your Honor, it would be something interesting for the court to examine had Ms. Schaefer raised the issue below. In response to the motion to compel, there was no discussion of privilege. There was no objection based on privilege. There was no objection to any discovery request based on privilege. There was no objection to, the subpoena, timely or otherwise. There was no motion to quash the subpoena. The issue of the attorney-client privilege was even raised in Ms. Levy's motion to compel. Ms. Schaefer didn't respond to the motion to compel based on the attorney-client privilege. There's nothing in the record for the court to observe to find any discussion of privilege whatsoever that Judge Branch could possibly have looked at for the court to say that Judge Branch got it wrong.
That's not what I was asking whether she got it wrong. My question was, when there is clearly, in the order, it implicates attorney-client privilege because it asks for Ms. Schaefer's communications between her and her attorney. So by nature, that implicates privilege. So, under the statute, we have jurisdiction to consider something that implicates privilege immediately. So
It's possible, Your Honor, but the issue wasn't raised below, so the record was never developed. So we don't know that it actually implicates the issue of privilege. There could have been discussions, there could have been waiver issues before. There was a whole trial for a week, in which Mr. Schaefer testified. And to that point, Ms. Levy asked for the Court of Appeals and for Ms. Schaefer to designate additional portions of the record and the transcripts below to get at the issue. Ms. Schaefer refused twice to do so, saying that she had everything she needed in her record to advance her argument on appeal. We don't know that those communications, documents, and records have anything to do with the attorney-client communication or the attorney-client privilege. It wasn't asserted below, nor was there any request for an in-camera.
Counsel, isn't there an email in the record below that Ms. Schaefer submitted as an exhibit, in which she does say, I assert the client counsel privilege?
There's an email attached, there's an email from her former counsel attached to an interrogatory response, in which she does bring up the attorney-client privilege. First of all, that response was untimely. Second of all, upon filing the motion to compel, Ms. Schaefer's new counsel didn't object based on privilege. When I had communications with Mr. M, who's not here today, about the issue, he never raised the issue of privilege. And the issue was never put before Judge Branch. So there was nothing for Judge Branch to even think about whether or not there was a privilege issue, because the party who has an obligation to preserve it failed to raise the issue.
So I guess is it your position then that if one party seeks what by definition are communications between attorneys and clients, and there's no record and nothing's developed and no law is put forward, no privilege is asserted, that the attorney-client privilege can be evaded because it's not been developed or asserted in some way?
To that point, Your Honor, Ms. Levy was no longer a party to the action below. She had been granted default judgment on her claim for abuse of process. All that remained for Ms. Levy was her damages hearing, which happened in August of last year, and the issue of frivolous conduct sanctions. So she was no longer a party to that case.
Well, okay, but let me make sure I understand. I thought Ms. Levy was still seeking frivolous conduct sanctions.
She is.
She's still in the case in that regard.
Yes, that's true, yes. But she was no longer a party to the trial that proceeded in the summer last year. And it's possible that some of these communications could have involved attorney-client privilege, but we don't know that. I don't think it's for the court to assume the privilege is implicated, particularly when Ms. Schaefer's counsel never raised the issue below. And they had many, opportunity after opportunity to do so. They also had opportunity to designate additional portions of the record that would point to any discussion of privilege. So they could point to the Court of Appeals and say, this is where Judge Branch got it wrong. They elected not to. They proceeded on the record as designated. And there's nothing in the record that would suggest any issue of privilege as raised by Ms. Schaefer below to suggest that Ms. Levy got it wrong, or Judge Branch got it wrong.
Can you address the Rule 45 subpoena issue? Could a subpoena be sent to Ms. Schaefer given her status in the case at the time of dissent?
The rule is clear that Rule 45 subpoena would be sent to non-parties. However, that is an issue for an interlocutory appeal. That's a standard issue that comes up below in discovery that has nothing to do with whether or not the instant appeal before the court, whether there's jurisdiction for the Court of Appeals to hear it, based on the fact that it's just a standard appeal from a standard discovery order. So that issue could possibly have been live, but not for purposes of an interlocutory appeal. It's irrelevant, the merits of the decision below are irrelevant when it's just for purposes of appellate jurisdiction now. Those issues would be raised on appeal at a time in which it was no longer interlocutory. The statute says, now you have a final and appealable decision to appeal from. So, the issue of the merits of the discovery itself is within Judge Branch's discretion. It's not appropriate I don't think it's appropriate to discuss the merits of Judge Branch's discretion when the Court of Appeals doesn't have appellate jurisdiction to hear an interlocutory appeal of a standard discovery order.
Well, I'm gonna pose a hypothetical. So hypothetically, let's say that we have jurisdiction over this, because let's say that we believe that this does, implicate privilege. Okay?
Yep.
So that would make it a final appealable order if we were to determine that. So based on that, and if we were to ignore the Rule 45 issue, if we were to look at it on the merits, being that the communications were between a client and an attorney, should the court have had an in-camera review?
Had Ms. Schaefer asked for an in-camera review, there would have been documents for Judge Branch to review to determine whether or not there should be an in-camera review, whether or not any of those materials were privileged. That issue was waived. It was not brought up below. It cannot be brought up on appeal for the first time, this appeal would be the first time the issue of whether there should have been an in-camera review, whether it was a privilege issue, has been raised. So as a matter of law, that issue is waived. It cannot be brought up on appeal, absent some plain error, which is not alleged here, it's not present here.
Mr. Adams, I just want to call from the record, but at the time that subpoena was issued requesting Surratt, was Schaefer represented by counsel? Not that it makes any difference, but was he represented by counsel, or did Mr. N come in later?
He was not represented by counsel by choice at that time. It wasn't until a few weeks after the trial that she retained additional counsel.
I understand to be held to the same standard.
And it's the Grace case that, from the First District that the appellant relies on, the most important language in that case is that in determining whether communication by a client to an attorney should be afforded the cloak of privilege, much ought to depend on the circumstances of the case. The case does not say that in all cases an in-camera review is required. In fact, there was a later case from the Fourth Appellate District, the State versus DuPont, 21 Ohio 2614, that analyzed Grace and said, sure, in that case, an in-camera review was appropriate because it was asked for and because the party opposing production made an argument, submitted an affidavit, submitted testimony saying these records are privileged. There should be an in-camera review. The DuPont case distinguished its holding on that basis, much like here, saying there was nothing below for the trial court to think about in terms of privilege because there was no objection and there was nothing put into the record, no affidavit or otherwise, saying these records are privileged. There was no privilege log. It was just a blanket assertion of privilege. And so,
something I'm struggling with conceptually in this case is the notion that the attorney-client privilege can be invaded if it is not procedurally asserted. And that's, I think what I'm hearing is that a party can ask for another party's attorney-client privilege documents. And if that other party fails to comply with some technical rules, or merely just sits silent, that the attorney-client privilege is de facto waived.
it's not a de facto waiver, I would say, Your Honor. The attorney-client privilege can be waived by a party's conduct. Acts and omissions can operate as a waiver of a privilege. we're not arguing the waiver of the privilege today, we're arguing that the privilege was never raised at all. Despite many opportunities for it to be raised, it wasn't. So in that sense, the argument was waived. It was absolutely waived on appeal because it wasn't waived, or it wasn't raised below.
But isn't that in effect saying the privilege cannot be asserted because it wasn't timely raised, and therefore it's waived?
I do not, Your Honor. I think if even untimely below, if it was raised after the compliance time for the subpoena or after discovery requests or interrogatories were due, if the issue had been raised, a more than plausible argument could be made that the privilege was preserved. But it wasn't raised. So there's nothing for Judge Branch to rule on. There's nothing for the Court of Appeals to look at in the record to find that she did anything wrong.
To follow on Judge Fox's hypothetical, if we were to determine that the attorney-client privilege did apply, and we were to remand this back to Judge Branch for in-camera inspection, all of this could be developed, right? And I understand from the arguments that you advanced in the trial court that you would be arguing that the privilege was waived based on Ms. Schaefer's conduct, right? And that could be much more fully vetted out at a hearing, right?
It certainly could have been, but the fact that I argued that the privilege was waived was all the more reason for Ms. Schaefer to preserve the privilege. The party to whom the privilege belongs has a duty to protect it and can't wield it as a shield while also as a sword. I'm not saying that that's just an example of, misuse of the privilege, but here, the issue was raised by Ms. Levy, and it was ignored below several times. It was ignored on appeal. It was brought up for the first time on appeal. And I think that the assumption that these records actually include privileged material is premature and undeveloped, particularly because the issue wasn't raised below.
And so it could all be the Christmas cards or something.
Could be, Your Honor.
Yes.
Could be, and that brings us back to all this is an appeal from an interlocutory discovery order that is improper under the statute.
We have about 30 seconds if you want to wrap up.
If there's any other questions, I will happily entertain them, otherwise I'll reserve on the brief.
Thank you.
Thank you.
You have about 8 minutes to report.
Thank you, Your Honor. I think what my colleague is suggesting is that this court should not issue an order because, well, Ms. Schaefer can produce the documents and communications between her and her previous counsel, and then after everybody's been able to view those documents, we can decide whether they're actually privileged or not. That is unfortunately, the genie will already be out of the bottle by that point. There is
Well, isn't that the
something.
purpose of a privilege log? I mean, a privilege log would then identify, there's an email on this day, there's a letter on that day, there's a text message on this day, and then the court would review that to ascertain whether the privilege applied or didn't to the particular communication.
Under a conventional discovery process, yes, Your Honor, that would be what a privilege law would do.
What about your opponent's perspective that this could all be what I'm calling the Christmas card material? This could all be non-privileged communication at the outset, and how do we know that there's any attorney-client privileged material in the universe of responsive documents?
For starters, we don't, because we don't have the benefit of an in-camera review or any developed record.
But wouldn't it be on your client to come forward with that information to say if there is attorney-client privileged material and what's responsive to the subpoena?
I think my client is entitled to a presumption that the documents, communication with ESI regarding the removal of the 2 pine trees that she's accused of removing for a spoliation claim is likely attorney-client communication.
Do you have any authority that's on point for that assertion? That she's entitled to that presumption?
No, Your Honor, other than, it's clearly a seeking documents and production that
goes to exactly what Ms. Schaefer would be discussing with her counsel at the time. I just think it's part of the reality of practicing law, that if my clients, my client and I are certainly talking about what the matters are that are at issue. On the matter of whether or not this court has jurisdiction to hear this complaint, or to hear this appeal, again, I note that, you know, other appellate courts have faced the same issue, and they have not held a failure to assert the attorney-client privilege at the trial court level in response to a discovery order. They have not held that against appellants in their districts. Like I said earlier, the second district in Halley versus Detmer Sons, which was in the briefing, dedicates an entire paragraph to explain that yes, counsel could have done better. Can acknowledge that counsel could have done better, made the trial court's job easier, but the trial court has not had the opportunity to address these arguments, and they don't believe that it's appropriate for them to, the appellate court to hear those arguments. It should just be remanded to the trial court to hold this in camera review or evidentiary hearing. Similarly, in the case Squire Sanders Dempsey LLP versus Givaudan Flavors out of the 8th District, that's 2009 Ohio 2490. In paragraph 74, they likewise decided to not hold the failure to properly raise privilege against the appellant. They did not believe that it was that fragile. The other issue here is that not every discovery order is immediately just treated interlocutory and non-appealable. The issuance of a subpoena does fit within the definition of a provisional remedy under Revised Code 250502. In re Disinterment of Glass, which is in the briefing, 2022 Ohio 28, the second district held the exact same, that it was an interlocutory appeal subject, or it was subject to an immediate appeal. Also, this court as well, in Lambda Research versus Jacobs, 2007 Ohio 309, at paragraph 16, the trial court, when ordering production under a subpoena, after rejecting any safeguards to protect the information that was going to be disclosed, this court did find that that was a final appealable order sufficient for jurisdiction over the appeal. So if the court doesn't think it has it on jurisdiction on the privilege issue, I believe it certainly does still on the subpoena issue that seems to at least implicate the attorney-client privilege. Again, the remedy that, but for jurisdiction, Ms. Schaefer will be likely forced to put her.
Counsel, your opponent is essentially arguing that Ms. Schaefer waived her attorney-client privilege or made an argument about her attorney-client privilege by not asserting it below. Can waiver come from silence, or does waiver have to come from some kind of affirmative action?
I think the courts have been pretty clear that I don't think silence waives attorney-client privilege. It's either consent or through testifying on that subject. I believe there's a common law way to waive privilege, but I don't think that silence is that means to waive it. I'd have to be wiser on that issue, but the issue of waiver was discussed actually in Grace versus Masterizo. There was a ruling out of the Ohio Supreme Court where the court noted, the first district noted that the Ohio Supreme Court had refused to adopt a judicially created waiver and limited the means of the attorney-client privilege to those enumerated by statute, which is by express consent or by voluntary testimony on the same subject. Now, the idea that there are other ways to waive the attorney-client privilege, they're not completely foreclosed, at least according to the Masterizo court, but I don't think any of them are present here. I think that saying that silence is a waiver of the privilege will lead to far too many pratfalls, and especially for people that are like Ms. Schaefer, at the time she was served with a subpoena, she was not represented by counsel. You know, one other thing, my colleague argues that Ms. Levy, at the time that the subpoena was served, was no longer a party. That is wholly untrue and unsupported by the record. She clearly is a party to the litigation. She sent a subpoena purporting to utilize the court's authority, which she cannot do if she's not a party. The trial court simply needs the opportunity to hold an in-camera review. And the trial court simply needs to be told that if these documents are going to be produced at all, they need to be requested under the proper mechanism. We already have a rule that's in place for requesting these documents, and that's through a document request. The document request also gives the opportunity for counsel to confer in good faith before involving the court of what is privileged and what is not, which would allow for a privilege bond to come in and, you know, not have to burden the court with any of the time and expense. So, in light of all of these foregoing, I would respectfully request that Ms. Schaefer receive the relief she seeks for review. Thank you, Lawrence.
The case is now submitted, and we will issue a timely decision. And that concludes our arguments.